Thank you, Madam President. In April of 2018, the California Supreme Court issued a decision that changed the work life of millions of Californians that departed from 30 years of California law and created a new test to determine who is not an independent contractor. The test, the ABC test, is a rigorous test which in an independent contractor must meet all three of the criteria in order to maintain their employment status. Part A of the test requires the worker to be free from the control and direction of the hiring entity in connection with the performance of the work, both under the contract and for the performance of work. And Part B of the test requires the worker that they perform the work that is outside the usual course of the hiring entity's business. And Part C of the test requires the worker that is customarily engaged in the independently established trade, occupation, or business of the same nature of the contractor where the work is performed. This ruling established the most restrictive form of employment testing relating to wage and hour laws found anywhere in the country. There are millions of Californians who choose to work as independent contractors. We have moms who work driving Uber while their children are at school and they set their own hours. The college students who work as DoorDash after class to afford high cost of living and add to their income. The manicurists who set their own appointments, rent their own booths, and choose to work as their own boss. These independent contractors are our truckers, our therapists, our optometrists, our caterers, our foresters, our interpreters, our media individuals and reporters. In fact, nearly 500,000 of millennials currently freelance, and 79% of independent contractors prefer this work over traditional employment. Instead of helping all of these Californians, this body has introduced AB5, which issues carve-outs to certain industries. This legislature should not be in the business of picking favorites, which is exactly what this legislation does. A one-size-fits-all employment test should not and cannot apply to these Californians to depend on their income from independent contract work. This is why I'm introducing the amendments to AB5, which would match California's employment test to the federal standard. If these amendments are adopted, we will all be in cohesiveness with the federal government standard, and there would not be a separate test for people that operate in the federal standard and the state standard, the people who will fall under the Borrello test, and the people who are in part of the carve-out. This benefits both workers and employees across industries by asking whether the worker is economically dependent on the hiring entity. This test accounts for diversity of workplaces and will once again make a side gig, independent contract work, a freelance job, and it will be the option for all Californians again, and let California employees choose. Members, I urge you, for the sake of all independent contractors and the ones that are not covered under AB5. We've put amendments across the desk, and this bill has been amended several times because we don't know all of the effect that these people, that this bill will cover. We've excluded realtors, doctors, lawyers. There's been amendments across the desk for just newspaper delivery companies today, just to delay it for 1 year. But there are so many industries that are not part of this bill that have not been able to get a carve out that this bill is going to affect. And it's not just the gig economy that you're after. So I would ask for an aye vote on these amendments.
Senator Hertzberg, for what purpose, sir?
Thank you very much, Madam President. I move to lay the amendments on the table.
Thank you. This motion is non-debatable. A majority vote is required. Senator Hertzberg is asking for an aye vote. Senator Grove is asking for a no vote. Mr. Secretary, please call the roll.
Allen. Aye. Archuleta. Aye. Atkins. Aye. Bates. No. Bell. Aye. Borges. No. Bradford. Aye. Caballero. Aye. Chang. No. Daly. No. Dodd. Aye. DeRazzo. Aye. Galgiani. Aye. Glazer. Aye. Gonzalez. Aye. Grove. No. Hertzberg. Hill. Hertzberg. Aye. Hill. Aye. Hueso. Aye. Hurtado. Aye. Jackson.
Aye.
Aye. Jones. No. Leva. Aye. McGuire. Aye. Mitchell. Aye. Monning. Aye. Morlock. No. Morrell. No. Nilsson. No. Pan. Aye. Portantino. Aye. Roth. I, Rubio. I, Skinner. I, Stern. I, Stone. No, Umberg. I, Wachowski. I, Wiener. I, Wilk. No.
Ayes 29, noes 11. The amendments are laid on the table.
The design industry is highly specialized, in which you may need one type of engineer or surveyor for one particular job and someone with another subspecialty or experience for another job. Without the ability to contract with these individuals, projects will suffer due to the lack of qualified professionals. Members, I ask that you support the amendments and vote aye on the amendments.
President, I move to lay the amendments on the table.
Mr. Secretary, please call the roll. Senator Hertzberg is asking for an aye vote. Senator Jones is asking for a no vote. Please call.
No.
Ayes 29, noes 11. The amendments are laid on the table.
Amendments for the following, for the following occupations: licensed timber operators, land surveyors licensed pursuant to the Professional Land Surveyors Act, contractors licensed pursuant to contractors' state license law, geologists and physicists licensed pursuant to the Geologist and Physicist Act, engineering license pursuant to the Professions Engineering Act.
I move to lay the amendments on the table.
But is there any objection to using the previous roll call? Seeing and hearing none, ayes 29, noes 11. The amendments are laid on the table.
Madam President, ladies and gentlemen, this particular amendment will define health facilities in subdivisions A to H inclusive, section 1250 of the Health and Safety Code, which contract with companies that employ health care providers who provide services to patients and their facilities. Amendments 2, 3, 4, and 5 are technical and associated amendments. And I will argue that this is probably one of the most critical areas of all that need to be removed from the provisions of this onerous decision. We have a paucity of health care providers of all sorts in California, particularly in our rural areas. This particular provision will be very, very onerous, a great burden to all of us, and I will be jeopardizing the quality of health care available to us. I ask and I vote.
Thank you, Senator Hertzberg.
Thank you very much, Madam President. I move to lay the amendments on the table.
All right, this is non-debatable. Is there any objection to substituting the prior roll call? Ayes 29, noes 11. The amendments are laid on the table.
So long as the conditions for exclusion from employment in the newspaper distribution industry under that section of the California Code of Regulations are met. I ask for an aye vote on this amendment, and as stated, the bill threatens to rip that piece of democracy right out of our grip per the Sacramento Bee. Thank you.
Thank you very much, Madam President. I move to lay the amendments on the very crowded table.
Very good, thank you. And this also is non-debatable. Any objection to substituting the prior roll call? Seeing none, ayes 29, noes 11. The amendments are laid on the table. Senator Wilk on the amendments.
Thank you, Madam President. Members, the table is about to get a little bit more crowded. So my amendments on page 7 between lines 31 and 32, please insert number 7, an owner-operator as described in section 34624 of the Vehicle Code if all the following are met. I, the owner-operator owns or finances a power unit as described in subdivision A, B, F, G, or K of section 34500 of the Vehicle Code. Double I, the hiring entity or broker of trucking services shall not own, lend, or have any other financing, investment, or lien hold interest in the power unit. III, the owner-operator shall have the sole ability to negotiate and set the contracted rates for the use of the power unit or to accept or deny the work based on the offered rate or for any other reason, including but not limited to the route, destination, or material to be hauled. And section 4, The owner-operator has valid motor vehicle permit and carrier identification number as described in sections 34620, 34507.5 of the Vehicle Code, Code Section 74056, and operates the power unit exclusively under the permit and carrier identification number, or operates pursuant to an agreement which is subject to Part 376 of Title 49 of the Code of Federal Regulations. It should be noted that the court itself excluded owner-operators from being part of the class in Dynamex Operating West versus Superior Court, thus protect our independent truck owners and operators by passing this amendment.
Thank you very much, Madam President. I move to lay the amendments on that table.
This is non-debatable. Is there any objection to substituting the prior roll call? Seeing none, ayes 29, noes 11. The amendments are laid on the table.
Sorry, I got a little anxious to load up the table.
It's okay. No problem.
So these amendments apply to our franchisees and our franchisors. So basically, this amendment is: a franchisee shall not be deemed an employee or a franchisor to the franchisor and shall be considered an independent contractor unless the court of competent jurisdiction determines the franchisor exercises a type or degree of actual control over the franchisee. The franchisee's employees, and that is not customarily exercised by the franchisor, and for the purpose of protecting the franchisor's trademarks, service marks, or trade dress, for purposes that include but are not limited to quality control of products and services. These amendments are important to make sure that our franchisees, like McDonald's owners and others, will be free from this bill.
Thank you very much, Madam President. I move to lay the amendments on the table.
Non-debatable. Is there any objection to substituting the prior roll call? 29 aye, 11 no. The amendments are laid on the table.
This is like a painful filibuster here. I rise today to present an amendment to AB5 in order to exempt the language services industry, which employs thousands of translators and interpreters in California. Interpreters, translators, and linguists should not be included, I submit, in the gig economy. AB5 will not only limit individuals' ability for flexible employment, but will destroy entire industries across California. Colleagues, I respectfully request an aye vote with these amendments.
Senator Hertzberg.
Thank you very much, Madam President. I move to lay the amendments on a second table. There's no more room on the first table.
Right. And more to come. Any objection to substituting the prior roll call? Seeing none, ayes 29, noes 11. Set 8 are laid on the table.
I would like to offer an amendment for TNCs in set 9, colleagues. The sharing economy, the gig economy, transportation network companies. So if you want to be a taxi driver and you want to do it in your spare time after your regular job and you just do it for some spare change and some extra money to make ends meet, pay the rent, then you should really be an independent contractor. But if you want to do it full-time, do it as a shift, and you want to work from 8 to 5 or whatever, then maybe you're an employee. So maybe we should be taking some time to figure that one out. There is room for both independent contractors and common law employees. The amendment requests a 1-year deferral. It allows for time for all parties to mutually agree on their status, full-time shift employees or part-time extra income earners. I request an aye vote on the amendments. Thank you, Madam President.
Thank you, sir. Senator Hertzberg.
Thank you, Madam President. I move to lay the amendments on the table.
Non-debatable. Is there any objection to using the prior roll call? Seeing none, ayes 29, noes 11. Set 9 is laid on table number 2.
Members, I rise to amend AB5 to exempt the profession of physical therapy from the bill's provisions. This amendment would allow physical therapists to maintain the necessary flexibility of private contractor status to serve their patients. They are often assigned to provide physical therapy to patients in home environments following significant health events. They are also referred by hospitals or other agencies to patients for their services. As authorized by their license and scope of practice, they independently evaluate, assess, and develop a treatment plan for a specific patient's needs. They schedule appointments directly with patients. They bring and use their own medical equipment and working with the patient. They even bill insurance companies when relevant, directly for their services. The same is true in nursing homes, in which a physical therapist may have a patient or multiple patients, but not enough for a facility to employ a physical therapist. These are just two of many examples in this industry demonstrating complete independence. People who have chosen this job for the love of helping others. Warning exemption would be nice from the Dynamex ruling. It is important for them to maintain private contracting abilities in order to continue to provide treatment to patients of all different needs and locations, including physical therapists, and a blanket mandate prohibiting private contracting will certainly negatively affect patients at the level and diversity of care they are provided. Members, I ask you to please support this amendment to AB5, affectionately known as the carve-out bill. Thank you.
Senator Hertzberg.
Thank you very much, Madam President. I move to lay set 10 of the amendments on the table.
Non-debatable. Any objection to substituting the prior roll call? Seeing none, ayes 29, noes 11. Set 10 of the amendments is laid on the table.
Members, I'm very happy to present the amendments to AB5 that will exempt nonprofit organizations from the Dynamex application. This amendment is necessary to allow thousands of nonprofits, I know that many of which are very important to you, that the state continues to operate without fear of having to close their doors and ceasing to help others. Nonprofits provide vital services to low-income and disadvantaged Californians across the state. And my fear is that the Dynamex decision will drive many of these nonprofits out of business. Some examples of some nonprofits that might be important to some members of the Senate: the American Civil Liberties Foundation, the American Heart Association, the American Red Cross, the National Audubon Society, St. Jude's Children Research Hospital, the Natural Resource Defense Council, PETA, San Diego Zoo Global, the Mayo Clinic, the Alzheimer's Association, breast cancer care centers, homeless shelters, women's shelters, refugee humanitarian centers, immigrant legal services, food banks, Planned Parenthood, Rotary, and a big concern of mine is rabbis to perform baby namings, of course, and brisses. I ask that you vote on this important carve-out for these very important nonprofit organizations that partner with governments to provide needed services for the citizens of the state of California. I request that you accept these amendments.
Thank you, Senator Stone. Senator Hertzberg.
Thank you, Madam President. I move to lay set number 11 of the amendments on the table.
Non-debatable. Is there any objection to using the prior roll call? Seeing and hearing none, ayes 29, noes 11. Set 11 is of the amendments are laid on the table.
I rise today to present the amendments to AB5. Earlier today, the Republican caucus attempted to even the playing field for all independent contractors. Then this body ignored the pleas from healthcare facilities, the design industry, including landscape architects, geologists, geophysicists, then veterinarians, accountants, land surveyors, franchisors and franchisees, physical therapists, interpreters and translators, newspaper carriers and distributors, truck owner operators, forest engineers, and licensed timber operators. Now I bring before the Senate an amendment that would help those deal with the repercussions of this bill that you've agreed to keep in its current form. This amendment to AB5 would delay the effects of the Dynamex decision for 2 years, so we can give those who refuse to help time to prepare for the impact of the decision. It will also help prepare the legislature to create further solutions to this decision, which our body has admitted will come in the next session. This is a compromise that we should all agree is only fair, If this body is going to pick winners and losers, it should also help those who are hurting to be able to meet the requirements of such laws. I ask for an aye vote on the amendments.
Senator Hertzberg.
Thank you very much. I move to lay, I believe, the final, this number 12 set of amendments on the table.
Non-debatable. Is there any objection to substituting the prior roll call? Seeing none, ayes 29, noes 11. The amendments are laid on the table.